And we're going to go ahead and start. And I'm sure there will be folks joining us for the next couple of minutes. But welcome and thank you for joining the December informational webinar. And the topic today is guardianship and the alternatives. My name is Drew Andrews. I'm the Assistant Director here at the Florida Center for Students with Unique Abilities. This webinar is being recorded. Handouts can be downloaded from the chat section where you can access that through clicking on the chat icon down at the bottom of your screen. Also, closed captioning can be accessed at the bottom of your screen. Our presenter today, is Catherine Davey. She is counselor at law with the Davey Law Group for nearly 30 years. Catherine Davey has practiced law. She focused her practice on probate, guardianship, guardian advocacy, estate planning, and the drafting and implementation of special needs trust for individuals with physical and developmental disabilities. She received her Bachelor of Arts from George Washington University in Washington, D.C., her Juris Doctor from Stetson University College of Law in St. Petersburg, Florida, and her Master's of Law in transnational business practice from the University of the Pacific's McGeorge School of Law in Sacramento, California. We're so glad that you're here today to join us. And at this time, I'm going to turn it over to Catherine.
Hey guys, I'm Catherine Davey. I am delighted to talk to you about guardianship and the alternatives. I have now actually been practicing law for a little more than 30 years. The beginning of November was 30. I'm going to share my screen with you and start my presentation. And I always start with a frank discussion of why I am here. And it is not just because I'm a super altruistic attorney who thinks this is important stuff you guys should learn, which is all that true as well. But I have a vested reason. And I always say that I'm here to, change the world for one little girl. And I'm happy to change the world for lots of other folks as well. So there's my daughter, May. You'll see lots of photos of her as we go through the program. She is adorable. And my other daughters as well. They've heard me make fun of them. They've all heard me make fun of them. So don't feel like, oh gosh, she's making fun of her kids. They would be appalled to know that she does that. I promise you, they've all heard the presentation. I've done it to their face and they all know it's coming. So, and they know it's out there. So here we go. Now I do this, but is it gonna, there we go. Okay, so let me give you the agenda of what we're going to do, and that is all three of my daughters. My oldest is now almost 21 and a junior in college. My middle on the right-hand side there is a senior in high school waiting for those college acceptances. And my youngest is May, and she's there in the middle surrounded by her sisters. We are going to talk about guardianship and the alternatives. We're going to talk about supported and shared decision-making, as well as substituted decision-making. I'll explain what all those things are. Guardianship, guardian advocacy, guardianship, next steps, and what else do they need to know, as well as resources. So where I always start and why I do this and why I'm so passionate about this is because nearly 10 years ago, when my then husband and I had our youngest daughter, what I heard in the community of parents was fear and misinformation about what I did for a living every day. And I thought, I can fix this, I can change this. What people need is education and information, so they understand all the range of options they have. And then I realized that attorneys weren't as educated as they should be about it, and judges weren't as educated as they should be about it, nor were other folks, right? So then it became, I have to educate everybody. So it's not just parents, it's everybody who needs this information. So that's why we're here today. I do a program called Low Down on Law, and twice a year in partnership with the Down Syndrome Association of Central Florida. That's why you'll see the logo on the bottom right-hand side. Everything has to be a play on words, right, for Down syndrome, because that's what my daughter has. So I started a nonprofit called No Downside. Like you can see a little pattern going. So, all right. Why do parents have to do something at all at age 18? Well, the reality is everyone is presumed competent at the age of 18. unless a judge determines otherwise. So you are, right? Whether May has the ability to make decisions for herself at 18 or not, she is competent in the eyes of the law. Now, I've heard other people say, well, you have to get a guardianship at 14. Well, the reality is you're still incompetent at 14, right? In the eyes of the law, you're still incompetent. And even though my 17-year-old is convinced that she's completely competent and doesn't need anybody's help, except maybe my credit card, she's not, right? In the eyes of the law, she is not competent. She will be in April, but she's not yet. So that's why, right? You got to do something because that's the legal presumption. But what are some of the fears that parents have? They're afraid that they're no longer going to be able to make medical decisions or consent to medical treatment for their child, that their child would be exploited or taken advantage of in some way, maybe financially, that no one will be able to help their child or let me help them, that I can no longer advocate for my child or protect them, and I can no longer advocate for them in school, right? Those are all really valid concerns. And I'm going to talk you through lots of options that you have that aren't just all legal ones, right? You've got lots of other options as well. So how can we address those fears? So if your concern is financial abuse, freeze your kiddo's credit. Here's the tiny URL. It's a whole long thing through, but we've given you the tiny URL so you can get to the thing and just freeze their credit. You can do that the minute your child's born. Doctors won't talk to parents or discuss treatment. Well, then if your kiddo is able to, they can sign a release of information or a HIPAA release. If you're concerned there'll be no one there to act on their behalf, maybe even after your lifetime, don't forget about your own estate planning, right? And I remind parents of this all the time. And what if my kiddo has behaviors and I can't protect them anymore? Well, there are registries. I know there's definitely a mixed bag and mixed emotions over that, but there's registries available through the Orange County Sheriff's Department. They're identifying bracelets, seatbelt covers, shoe tags, right? There's everything now. Have I quite gotten to the point where I've put the Apple tag in my kiddo's shoe? Not yet, but she does love to get away. So we'll see, right? Those are all options. And if educators won't talk to parents, if a kiddo can do it, then they could sign the FERPA release, right? They're working on an education proxy. That statute hasn't changed yet or passed yet. I love a graphic. I love a visual. It helps me remember how things work. So I've used the Florida Developmental Disability Council's graphic for this. So you have that real mental image of supported decision-making is the least restrictive thing we can do, and guardianship is the most restrictive thing we can do. And there's lots of options in between, okay? All right, I always describe supported or shared decision-making in exactly the same way. You turned 18, you went to the car lot with your mom or your dad, or you bought the neighbor's car or whatever it was, but there was a whole tribe that went with you. It was your mom and your dad and maybe your aunt or uncle or whatever. There was a whole group of people. And maybe mom looked at the financing stuff and dad looked at the car or vice versa to give you guidance and help you make decisions. That's what supported or shared decision-making is. Different people get assigned different roles to support the decision maker and give them guidance. Sometimes they're even there to express the decision of the person with a disability, but that's in concept what it is, okay? I've given you some information from the ACLU's website. There are written agreements that you can create to the extent the person with a disability can sign it. They call them supporters versus decision makers. There is a law that's presently being considered in the Florida legislature, HB 73, and they're looking at adding language to the statute that covers guardian advocacy, which is 393.12. It is not currently the law in the state of Florida. It's being considered, but it is not currently the law. And supported decision-making has been raised in the last 3 legislative sessions. So it is likely coming our way. And the Florida Probate Rules Committee and the Florida Bar are very active in having those conversations with those other groups that are passionate about supported decision-making to make sure it's something that will be viable in the state of Florida and can be managed. There are potential problems, as with any statute or anything, with supported or shared decision-making. Number one, I've already told you, it's not currently the law in the state of Florida. Is it possible to use supported decision-making? Absolutely it is. but it's not currently the law. So if you go to Bank of America with a supported decision-making agreement, they may or may not accept it because it's not currently the law. It works until it doesn't, right? Because it's not the law. If it works for you, that's great. I'm really glad to hear it because I know people aren't excited about joining the justice system. I got that, or the legal system, but it's, if there's a problem, it's going to be a problem. Lawyers are also very concerned about the potential for fraud and undue influence, manipulation, coercion, or other abuse, right? That's one of the biggest things we've had to work our way through through those negotiations. So we're concerned it could be a huge boon for litigation. So what we always tell people is proceed with caution, right? Tough to tell how well this is going to go until it's actually a law. And even then, there's going to be a learning curve for a long time. I've given you a ton of information. So if this is something that feels right for the people you work with or the families that you work with, there you go. I want to make sure you have the most accurate and up-to-date information. All right. Next up in that triangle, right, from least restrictive to more restrictive as we climb up, is substituted decision-making, right? This is what everybody has, right? If you've done any sort of estate planning at all for yourself, it is very likely that you've done a power of attorney, a healthcare surrogate, that kind of thing. A power of attorney is usually about money, right? I always do the hand, the running the coins through my fingers thing so people understand the difference. A power of attorney is just a legal document where I'm delegating the legal authority to make financial decisions for me to Drew. I'm going on a trip around the world. I want to make sure that Drew can pay my bills if I can't. And so the bank is going to recognize my power of attorney because it's very clear, it was drafted by an attorney, and so that Drew can manage my affairs while I'm on my trip around the world. Okay. It can be very broad. It can't be like anything I ever need to do ever, like that'll never get accepted, but it can be a 10-page document, and mine is, where it details every single thing that Drew could possibly do for me. Okay. It can also be very, very narrow. Drew, I'm going on a trip around the world and I'm trying to sell my house. So I just need you to sign off on that stuff. So it could be that my power of attorney just says, Drew can sell my house for me. Okay. So it could be broad or it could be very limited. Must a person, and I had this come up when I first started doing this education, and I didn't really fully understand how this was possible, but I want you to listen carefully to what I'm going to tell you, because the question is, must a person be competent to sign a power of attorney? And of course, the answer is yes, but here's the bar they have to cross. The principal must understand the power of attorney document when it's signed. They have to understand the effect of the power of attorney, to whom it's given, and what property is affected by that power of attorney. That's not all that high, right? Can I tell you right now with 9-year-old May whether or not she'll be able to understand that when she turns 18? I don't know, but if all she has to do is understand that she's signing a power of attorney that gives me the right to make decisions for her and what's covered by that, she might. So healthcare surrogate is exactly what you think it is. Who's going to make healthcare decisions for me if I can't? So Jennifer, I'm sick, I'm in the hospital, the doctor comes running out, I've been in a car accident, I need you to make healthcare decisions for me because you're the person I picked. Okay, that's what that is. And every competent adult has the right to choose someone to make decisions for their health, including the right to choose or refuse treatment. So can they sign advance directives? Absolutely, they can. I've given you the statute so you see that that's true. However, just like supported decision-making or shared decision-making, there's downsides and potential problems. So neither the power of attorney, Drew, or Jennifer, who's my healthcare surrogate, can do things that are against my will. So Jennifer says, Kath, you really need to stop with the donuts. It's not good for you. You've got all these problems. Stop eating donuts. She can't stop me, right? She can't force me to go take my medicine. She can't force me to go to the doctor. She can't force me to do anything. Okay. Drew sees me playing the international lotteries and doing crazy things with my money or giving my stuff away. He can't stop me. He can make decisions if I can't, but neither of those people can stop me. So I always want to make that really, really clear that it's a great tool, but it's not a trump card. You don't win in the face of conflict. You only get to make decisions if they can't for themselves. Okay. All right. So guardian advocacy. Next up on the triangle of things we have options for. This is a guardian advocacy I did for a dear friend and her daughter out in Lake County. That's Judge Takis. So adorable photos had by all. Guardian advocacy generally is really just a streamlined legal process where the court will remove certain rights from a person with an intellectual or a developmental disability and appoints a guardian advocate to make specific decisions for that person. And it's done with all that same oversight and control of the court for the lifetime of the person with IDD until those rights are restored to that person, if that's possible. I've definitely had those cases, and I'll talk through some of those examples in just a second. Okay. All right. Guardian advocacy. How do we get there to begin with? I've just told you it's an intellectual or developmental disability. So it's not a car accident. It's not dementia. It's not Alzheimer's. It's not you're having a bad day. It's a developmental disability as defined by the statute. And I'll give you that list in a second. The guardianship types are limited. In my world, it's limited or plenary. Plenary is everything. In guardian advocacy, I call it plenary-ish because in theory, the law said, not in theory, the law says very clearly that only some but not all rights can be taken away. But I will tell you many or most circuits are fine with taking away all rights if that's appropriate, right? They're not going to force you into a guardianship or force the individual into a guardianship if really, truly they can't exercise any rights. Okay. All right. Our list of developmental disabilities. Now, intellectual disability, I'm going to talk about in just a second, but you got cerebral palsy, Down syndrome, Phelan, McDermott, Prader-Willi, spina bifida. Now you're going to say there's a whole laundry list of others that aren't there. Where are they? How do you make this work if, all those other developmental disabilities aren't there? Well, we lump them into intellectual disability. So Angelman's, all the others that you can name off the top of your head, that's where we put them. But I want you to understand that it's not just that May has Down syndrome, but that it has to constitute a substantial handicap that can be reasonably expected to continue indefinitely. So if someone has cerebral palsy, but is very high functioning and really truly doesn't need the assistance of anyone for anything other than maybe some mobility issues, that's not guardian advocacy. That's a physical disability. This is really only if they need help making decisions and managing their affairs, right? Can they be safe when they're over their person and property? Okay. One of the things you wouldn't think intuitively, but instead I do, I press these hard because attorneys aren't required for this. One of the things I love about guardian advocacy is I can train parents and families, and they absolutely can do it themselves. Now, I'll tell you, when I walked into this world 10 years ago, there were no forms for this. There are forms for this, and I know there are because I helped create them. They're on my website. They're on the Down syndrome website. They're on the Ninth Circuit's website. They're everywhere I can get them because I want parents educated and empowered to take care of this themselves. I get it's complicated. I get it's hard. I get it doesn't always make sense because, I've been doing something 30 years. It makes perfect sense to me. It's all I've done. I understand it's confusing, but I'm trying to make it so that people can do these things themselves. Okay. Because I get in a really personal way how expensive it is to have a kiddo with special needs and how you're like, gee, what do I need? It's just one more expense to cover and doing a guardian advocacy. So a guardian is not required, an attorney is not required if the person does not have property. If they do have property, then yes, an attorney is required. But if all you're seeking is guardian advocacy of the person, then there's no attorney required for the guardian advocate. Now, for the person, for May, or a person with a developmental disability, just like in a criminal proceeding, like you see on TV, because we're talking about taking away some of her rights, then an attorney is absolutely appointed for her. Okay. So don't have people panic if they can't do that. So, all right. How do we get through our process with this? So while not required, how do we prove up that May has Down syndrome? We're going to file a letter or report from her treating physician that May has Down syndrome. It can be the karyotype that was done when she was born. It can be an IEP that was done. We actually also created, we call it a report of attending physician that goes through all the elements that the court would need. And for us, it mirrors the type of report that they would typically see in a regular guardianship. So the judges are going to be familiar with it, and hopefully it'll be manageable for the doctors as well. Because what we need to make sure that we're doing is we're doing these cases when it's appropriate, right? And only when it's appropriate. So if it's not appropriate, we don't, we need to do something else or much less. Okay. So I've talked about some of the options you've got. You've got my report of the of the treating physician. It can be an IEP. It can be, I've had judges accept old medical records from other states and countries, depending on what they had as they fled chaos or hurricanes or whatever. So judges are fairly liberal about this as long as it's pretty clear that the individual, the nature and extent of the disability. Because lawyers have to have lists and stuff to make our lives, to make it clear what things the person can control, I've broken it down into two sections. The rights that are delegable or can be given to someone else, or the ones that aren't. So, right, I can't marry for May, I can't vote for May, I can't have a driver's license for her, or travel, or even do her job, right? Those are things that can't be delegated to someone else. But in a guardianship, the right to contract, the right to sue and defend lawsuits, to manage property or make financial decisions, to determine where she's going to live, to consent to medical or mental health treatment. And this is the one I always hang with you guys, to make decisions about social environment or other social aspects of life. So I'm going to have, I want you all to give me some feedback on this, because I used to train a certain way, but now the more I've learned and the more Drew schooled me on this, I train very differently. But I want you to think about the right to make social decisions, about decisions about their social environment. And then what you're going to hear most commonly is the right to apply for government benefits, right? That's a big deal for mom and dad, because as their kiddo turns 18, they're going to give that a lot of thought as they go to do those initial, oftentimes, Social Security applications. All right. I also distinguish it between person versus property, right? What are the things that are tied to the physical person? Vote, marry, driver's license, travel, to be employed, to determine a residence, make medical treatment, to consent to medical treatment, to make social decisions, versus property or money. Remember, because if there's property involved, there's lawyers, or there's a lawyer for the guardian as well, or guardian advocate. And that's the contract, sue or defend lawsuits, apply for government benefits, and manage property. Okay. All right. But I always want people to understand, especially in the era of Free Britney and all the other people that have had horrible situations, or whether it's true or not about guardianship, every individual in a guardianship absolutely has the right to have an annual review of that guardianship report and their plan, and to be restored to capacity at the earliest possible time, to be treated humanely with dignity and respect, to have a qualified guardian, right? The court is going to vet all potential guardians, to remain as independent as possible, to be properly educated, to receive visitors and communicate with others, and to receive services and rehabilitation necessary to maximize their quality of life. I've added this to my presentation because I had too many people that didn't quite realize that to be a guardian or a guardian advocate for someone, that they had to be qualified. And parents and other loved ones get mad at me. Well, I shouldn't have to give you this information. Yeah, except for it's a job you're applying for. And the court's now looking at you to protect a person who has been identified as vulnerable. So if you've got some stuff in your background that might give the court concern, they're absolutely going to talk to you about it and decide whether or not you're qualified for this job. Okay. I will tell you, although there are 67 counties and many circuits throughout the state of Florida, it is often not 100%, it's not at all consistent across the state of Florida. Heck, it's not even consistent from county to county sometimes, what different courts do. Judges will do things based on their experience and the law. There's one county in, honestly, it used to be Volusia County, where they'd never let you do co-guardian advocates because they were convinced you could never do it. It would never work. Other counties have very pedantic rules about what they'll allow you to do, even though the law may say something slightly differently or slightly more or less restrictively. The court's there to solve problems all the time. And I'll talk to you in just a second about some of the ones they just kind of let us get past. So typically in Central Florida, I'm going to say it broadly, Orange, Seminole, Osceola, Brevard, Lake, Polk, the courts are going to take away only specific rights. And they're going to delegate those rights to whoever the guardian advocate is. And those are the right to apply for government benefits, right? That's that SSI and the Medicaid, to determine residency and consent to residential placement, to consent to medical and mental health treatment, to make decisions about social environment, and to make decisions regarding education and voc rehab programs. Again, I'll talk to you about social in a second. This can change based on the preference of the circuit or the judge, right? Okay, so different circuits require all sorts of different things. I've just talked to you about some of that. One of the things we're actually going to start instituting in my practice is, in order to be a guardian advocate, you cannot be a convicted felon, right? We were previously running reports that would tell us, and as does the court, because you're going to go through it, the parents are going to go through a criminal background check. If you are a convicted felon, it is in theory a barring event to be a guardian advocate. Now, I will tell you, I have some circuits that absolutely will say, this is something you did when you were 18 and a half, and it's fine. You've never had anything else happen. I've also had other courts, and I had this come up last week, where the guy had 21 misdemeanors, some of which were only a year ago. And some of them had been felony charges, but had been busted down to misdemeanors. I'm sorry, when you get to 21, like, that's a lot. No judge is going to be super enthusiastic about having you in charge of anyone. And the court includes in the questionnaire you have to complete in the application, you have to tell the court if you've been arrested for anything. You have to tell them if you've been convicted of a felony, but you have to tell them if you've been charged with anything. And if you don't, the judges get really angry because you're signing that under penalties of perjury. So I really can't emphasize that enough. The courts will overlook some stuff, but you better be truthful, and you better explain what the issue was and why it's acceptable, or why you've learned from the error of your ways, or whatever the explanation is, but you're going to have to explain it. And then the client with the 21 misdemeanors last week was, well, I shouldn't have to talk to you about my personal affairs. I'm like, yeah, you do, because you're applying for a job, and you're applying for a job for a person who's been identified as vulnerable. So yeah, you are. And they're going to run a credit check too. If you're going to manage somebody's property, they're absolutely going to run a credit check. If you have bad credit, or, bad checks, or multiple bankruptcies, the court's going to talk to you about that. And they may not let you act as the guardian of the property or the guardian advocate of the property, because it's shown that you can't manage money properly. So I talk to clients about that all the time. I also encourage clients to obtain ABLE accounts and open ABLE accounts for their kiddos, for their loved ones, so that they can save money and not have it affect their government benefits. I've also made sure you have copies of the statutes, right? Whether you look at them now or not, I want you to understand you have ready access to them. This is the determination-ish of incapacity of a person with a developmental disability. In theory, there'll be a hearing. Not always is there a hearing. Sometimes it's a very short hearing, if there is one, because really the heavy lifting has been done long before then. But generally, a court's going to appoint a guardian advocate without an adjudication of incapacity, right? There's not an examining committee. There's not a whole big hairy process. It's literally just the letter from May's treating physician that says that May has Down syndrome. She needs help managing her affairs, both personally and her property. And that's going to be enough. It's not a huge bar to overcome. They don't make it miserable. So you can also, and I always encourage clients, typically mom and dad are working their way through the guardian advocacy process. And I want them to also think in terms of whether or not they need someone behind them, right? Ultimately, I'm not going to want to be the guardian advocate forever. And I need someone to stand behind me, right? I call it Miss America and the first runner-up. I need someone in the first runner-up position. So in the event I'm unable or willing to perform my duties as obligations as Miss America, there's somebody else who's ready for that. Okay. And they know that they're the person who's going to have that job. this is kind of the photo of what you typically think of as guardianship, right? Dad's gotten older, maybe he's developed some dementia, he's got some issues. Guardianship can be for any reason. It's not just intellectual or developmental disabilities. It's a determination as to the level of capacity, and it can be based on everything from Alzheimer's to dementia to a car accident to just paranoid schizophrenia. It can be a medical diagnosis, right? It can be anything. And there'll be attorneys for everybody. There's 2 separate proceedings. Back in the old days, we had 2 physical files, the incapacity or the mental health side. You would petition to have someone determined to be incapacitated. There's been an examining committee, there's an attorney appointed, and in the guardianship side, and the examining committee is 3 doctors, right? So it's not just, gee, I think Drew's acting a little funny, I'm going to take control of his life. It's a whole thing, right? There's 3 doctors to get involved with. Everybody's writing reports. It's a big thing, right? You want it to be a big thing when you're taking someone's rights away. It continues for the lifetime of the warder until their rights are restored, which is always possible, right? In this context, the example I always use is you're in a car accident and you're in a coma, right? Someone's got to make decisions for you while you're in a coma, but when you wake up and you're feeling better and you're starting to regain your capacity, you're going to want to take your life back over, and you get to do that to the extent that you can. And there's a whole process for it. It's not hard. It's not challenging. It's just a process. It is hard and difficult in other states. In Florida, it is not. Okay. It is literally a single sheet of paper called a suggestion of capacity in a guardianship. And that suggestion of capacity can literally be you in court and you just say it, or it can be you scrawl it on a spiral bound piece of notebook paper, right? That's all it is. Okay, we talked about person and property. We talked about that before. The rights can be removed for anything. Both the guardian and the AIP need to be represented by separate attorneys, right? In the guardian advocacy, there didn't have to be 2 attorneys. In a guardianship, there is. If you are, and there will be a determination of incapacity. That's part of the whole process, is there really will be. I've given you, clearly I love a table, but I've given you kind of the breakdown of how it typically works. The basis on both sides, the types on both sides, how the rights can be removed, whether or not an attorney needs to be provided, the costs, right? The costs are sometimes completely overwhelming. So I do kind of a sliding scale for guardian advocacy, depending on how much I need to do. And I'll explain that in a minute. But then in a guardianship, right, we've got 2 attorneys, we've got 3 doctors, we've got 2 cases. It is a whole thing. And so, yes, it costs typically between $6,000 to $9,000 to establish that. I don't care where you are in the state of Florida, it's going to be at least that. And that assumes there's no conflict or drama, right? Conflict or drama among people, then it gets a lot worse. That instead of just a letter from a treating physician like there is in a guardian advocacy, there's a 3-member examining committee. And the timing aspect, right? I can do a guardian advocacy, and pretty quickly after the individual turns 18, guardianship takes 3 to 5 months. It's long. All right. Well, I don't know if you know, but in the Down syndrome community, we do a walk in October, which is Down Syndrome Awareness Month. There's some bragging rights over who raises the most money. I never raise the most money, but I delightfully come in 3rd place. This year, the theme obviously was Rosie the Riveter. So there's my nugget. All right, what's the right choice? And how do parents even decide what to do, right? I've given you all these options. Now, how do I know what I need to do? Well, remember, prior to the age of 18, everyone's presumed incompetent. Olivia Ann, 17 and a half, completely incompetent. Once she turns 18, we'll see. No, she will be. I don't want to know about all the decisions, but she will be. Everyone's presumed competent unless the court rules otherwise. So presume competency, right? But also know that you have to pick the least restrictive alternative that meets the needs of the loved one. And so how do parents make that decision? I'm going to show you the Wings decision-making toolkit, which I think is fabulous. But I also really encourage parents to go back to their treating physician, their trusted partners, their educators, the therapists their kiddos meet with and work with all the time. Because I tell people all the time, I overestimate my child and I underestimate her all the time. So trust those people who know your kiddo very well to give you feedback and input on which program you should be picking or which kind of legal option you should pick. I'm going to, like I said, I'm going to show you the Wings decision-making toolkit in a second, but also make sure that each one of us understand that individuals, and I know you guys know this, but I do this training to all sorts of people, that people may be nonverbal, but can still make decisions for themselves and are fully competent. So I've included the link to Elizabeth Bonker's valedictorian speech at Rollins College when she was obviously the valedictorian a couple years ago. So it's very powerful. All right. So here's the Wings decision-making toolkit. A bunch of lawyers and other folks got together and said, hey, how do we make this easier? How do we help people understand what the options are and the questions they should be asking? So here's the laundry list of questions. I literally make every single one of my clients who want to do a guardian advocacy for one of their loved ones do this questionnaire. It's a couple pages long, has a ton of great information. I gave you the link as well. And I always start at the top where it's super easy, right? The first question is, can I express my own choices and preferences? I will tell you that May Davey has no problem expressing her own choices and preferences. Today was dress in holiday colors, and her answer was no, that she was going to wear black and pink. And she was hardcore not wearing red and green. That's fine. I don't care. That's not the hill I die on. Can I ask my family, friends, or circle of support for help? Yep, she has no problem doing that. Can I communicate my approval to share information? Yep, all those things are easy. Can I plan what my day looks like? May would pretty much be eating goldfish and watching her iPad, but those are lots of good questions just to start. Then we move into employment. Then we move into money management. Can I manage my own money? Can I apply for government benefits? Can I make everyday purchases? Can I pay bills on time? Until it starts to get harder. Healthcare management. Can I make healthcare decisions about where, when, and what to eat? Can I take my medicine as directed? All the way down to relationships. Can I understand the need to consent to sex? I don't know if she'll be there at 18, but those are all really reasonable questions to make sure as we think through, and you end up with 3 columns, right? I can decide without support, I need support to decide, and I need someone to decide for me. And I make sure that all my clients go through this process and think through this. And so they have answers and have thought about this long before they get to me. Okay. All right. So what are the next steps? Captain Marvel here. That was that year. Determine what's right for their loved one with IDD. If supported or shared decision-making is the right choice for their family, that's great. Do your research and be aware of how best to support their family member. I've given you the links. I've given you some information. And in the previous slide, I gave you the information about how to do the written agreement to support a shared decision-making plan. What if it's substituted decision-making, right? Substituted decision-making, remember, is powers of attorney, healthcare surrogates, and all those things. I encourage everybody to use a reputable lawyer to prepare these documents. There are great lawyers who do this. Please do not download some form that your brother, sister's dog's best friend gave you. Please don't. Please don't have your friend, the criminal lawyer, do this. Unless they're an attorney who does this all the time, you're going to get something that's wonky and sideways. My power of attorney is 10 pages long. It is very detailed. It is absolutely executed in a very specific way to make sure it's absolutely valid. So whatever you might download from whatever is not going to have all that detail in there. I promise you. If guardian advocacy is best, these are the options I give clients all the time. So, and I always put it in the context of sort of like schoolwork, homework, because I think that's really the easiest to understand. So, as the first one is, can they work through the process independently using the materials available step by step? Can you just do it yourself? Have I given you enough information? Do you have all the forms? Can you just do it yourself? Great. Hope you can. Do you need an attorney to review the paperwork before submitting it to the clerk of the court? Also known as, I'm going to do my homework, but I want you to check it before I turn it in. Great. Awesome option. Do you need an attorney to prepare the paperwork and guide them through the process, but they can do the rest? So that I call that, I'm doing your homework and walking you through the process, but then you'll get it filed and go to court on your own. Or do you just want me to do everything for you? Which is also a fine option. I get as a parent of a child with special needs that I don't want to sometimes learn one more thing. I'm tired of learning the very unique way my child learns. I'm tired of learning all the very unique medical issues she has. I'm tired of the special emotional and sensory things she has. That adding, now I need to learn the legal system for the special things that are going to affect her may be just a bridge too far. I get that. And I have a whole practice built on doing that. If guardianship is the right option, then an attorney is absolutely required. But we're trying to set you up so if you can do it yourself, you can, and you feel confident about it. All right. So really practically, what does the guardian advocacy process look like? So you're going to file the initial pleadings with the court to get started. You have to go get your fingerprints done. I don't care if you had your fingerprints done a week before, a day before, a year before. I don't care if you're the president of the United States. Guess what? You're going to go get your fingerprints done again. And they're going to do an FDLE and they're going to do an FBI background check on you. So if you shoplifted at 18 and a half when you lived in New Jersey, guess what? They're going to find out. So it's important on that application, and I really just can't beat that to death enough. Tell the judge everything on the application. They will find it. You don't want them to discover it. You want to tell them. Notice to a credit check will be done as well. Notice to other family members is also sent. So if you are divorced, if you have some of your kids live somewhere else and aren't involved, I don't care. It's called an interested person, and every interested person is entitled to notice. So if you say, well, dad's not involved, he's a jerk. Unfortunately, I don't care. We're going to have to notice dad. Or if mom's a jerk. We have to notice everybody. There's a whole formal process for it. And what I generally tell clients is if you anticipate conflict or drama, don't do it yourself, right? That's when you absolutely have to hire an attorney. The court will appoint an attorney and an LSOR to represent the individual with IDD, and that person will be chosen by the court, or sometimes it can be proposed by the family as well. There's a hearing before the court on the petitions and the pleadings. It may be by Zoom, it might be in person, depends on the court. And, or sometimes there's not hearings at all. I've seen that both ways as well. Okay. Once appointed as the guardian advocate, they'll follow the rules for the duties and obligations under the Florida law, which includes annual plans, initial plans. You're going to have to go take a training, an 8-hour training. There's a lot to do. That is not all you have to do is just get yourself appointed. But I do always remind clients that you don't have to be guardian advocate forever. You absolutely can quit, right? There's a whole process for it. You can't just say, I'm not going to do it anymore and stop doing it. You have to get replaced and you have to be discharged and all those things. And also it may be with more education and maturity, may grow out of the need for some of the support that she's given originally. I've absolutely had those cases, and I am delighted to tell you, it makes my heart sing every time I can roll back parts of or all of a guardian advocacy or guardianship, right? As long as the person is safe and making good decisions, you know, to the extent they can, that whether or not you make good decisions is not the benchmark for whether or not you need to be in the guardianship, but whether or not you're legally competent is. So again, they file in a guardian advocacy. It's called a suggestion of restoration of rights. The court will examine one person, a doctor, to examine the ward, and that doctor will then file a report that makes recommendations as to which rights that can be restored to the ward. A ward is what the person's called in a guardianship. It is not a ward of the state, but it is like Batman and Robin, Bruce Wayne, right? Dick Grayson, whatever. Batman's ward. It's that kind of ward, because someone talked to me about this and they were confused and they're like, oh, they're a ward of the state. I'm like, no, they're your ward. Like Robin was Batman's ward. It's the same thing. Okay. And again, you don't have to be guardian advocate forever. You can't quit, but you can petition to be discharged, and you can pick someone to stand behind you as the standby or successor guardian advocate. I've got a ton of resources. I've actually gone a little fast. See, Drew, I knew this was going to happen to me. I'd go either too fast or too slow. I try to make sure you have all the information available. I have a ton of great resources. I have a ton of great stuff on my website. This is not a game of hidey ball. This is not, gee, how can I make your life harder? This is literally, how can I make it easier? What information can I give you to make it all make sense as much as possible? I've held questions to the end. Mr. Drew, do we have questions?
I'm sure that we will. And for everyone, you can either write a question in the chat, or you can unmute yourself and ask a question. This has been really an amazing, I'm thinking of folks that I know who aren't able to attend today, that I'm going to send the link, because we're going to be sending the link of this recording out along with the slides, which have also been available through the chat window. So let's see. Were you going to talk more about the social decision making? So
Yes.
there's
Okay.
a question about social decision making.
Okay. So I create problems for you guys all the time. And this is the one I learned a while ago. So we would, we're parents, we're paranoid. We don't want our kids to get taken advantage of. We don't want bad things to happen. So I'm going to keep my kid in a little bubble, right? I'm going to take her away her right to make social decisions. Except, what problems does that create for educators? What problems does that create for employers? How can May have a job if she can't make a social decision? How does she do how does she go to college? How does she do anything? How does she keep going? Think about your life and the social decisions you have to make every single day. Now, I can explain social decisions, more carefully so you understand it, but the way people generally understand it, if you can't make a social decision, or if you're in a guardian advocacy, I have those kiddos turned back to me by education groups going, they can't be here. Like, if they can't make even the most baseline social decision for themselves, they can't be in our program. And so we have to go back and maybe unravel some of that. So now I have really strong conversations, and I've been taught by some amazing people that if I let my oldest daughter's name is Emma. And when Emma went off to college, I knew full well, even though I wasn't quite ready to accept it, that she would make some interesting decisions as an 18-year-old that I probably wouldn't have made, okay, or don't want to admit that I made. But it was the dignity of risk, right? I'm going to let her go stumble and stub her toe and make mistakes. I have to be able to let May have that same opportunity to learn from her mistakes. I got to keep her as safe as I can. I don't want her to be taken advantage of or harmed, but I have to give her the dignity of risk. So that's my conversation about social decisions. So when you hear parents try to bubble wrap their kiddos, or you guys are trying to bubble wrap your own kiddos, that's what I say. We got to let them have social decisions to the extent they can.
Thank you. Thank you. Another question: what if you cannot afford $9,000 to have a guardianship prepared?
Mm-hmm. Well, and that's why guardian advocacy is an option, right? Because you can do it yourself. Now, if the person, okay, so let's pretend it's your dad. Your dad's incompetent. He thinks the cats are the dead relatives, and he's making bizarre financial choices, and he has no power of attorney and no healthcare surrogate. And you can't, and nobody can afford a guardianship. Well, guess what? There's no other option, right? In guardianship land, it's either power of attorney, healthcare surrogate, or guardianship, or bad decisions. So those are the cases I hate and I feel terrible about, but that's the reality. You can try to go through legal aid and see if legal aid can help you, but unless you're completely indigent, those are the two options. Now, in guardian advocacy, the options are different, right? Because I've given you the whole, you can do it yourself. You actually don't even have to have an attorney. You can just do it yourself. It's going to be hard. You will likely make mistakes, but I promise you, I have the judges come present at Lowdown as well. They don't yell at you. They're not going to mock you. They're not going to belittle you. And there's going to be a court-appointed attorney for the ward as well. And they'll help you, I promise. The other piece I want to remind folks is that court-appointed attorney for, in my reality, right? I always make it personal. I always make it May. So the attorney that will be appointed one day for May, it's not an adversarial process. Like, that attorney's not going to come in and be like, you're trying to steal her money. You're trying to take control of her life. You're trying to do it. No, everybody understands what the gig is. Everybody understands what the process is, why we're doing what we're doing. the folks usually who get court appointed on these cases are actually usually super involved in the special needs community. And so they understand what we're doing and why.
Can I follow up on the social decision making
Sure.
thing? So they can have this guardian advocate order from the court that just removes that piece, or how, so that we can at these programs for them to come and live on college campuses, that's the barrier is.
Mhm.
So what does that
So it
look
would be
like
the
for?
reverse, right? It would be everything but that.
Okay.
Or, right, because the whole laundry list, hold on, let me go back to the laundry list page. Oops, okay. Or break things. Also a good option. Sorry, look away if I'm making you crazy. Okay, so here's the list of the kind of the laundry list of rights. So you don't care if you're running an education program if May can't vote, marry, have a driver's license, or travel, honestly, or even have a job, or determine her own residence. You really just care about the right to make social decisions. So in theory, if I can do all the other things for her and she just has the right to make social decisions, you're fine. So what you're going to have to do is you're going to have to look at the letters of guardianship or letters of guardian advocacy or the order appointing the guardian advocate and see what rights were delegated and what rights were taken away. And it's delineated just the exact same way you see it in front of you. Does that make sense?
Yeah, so that's what the families need to be aware of, and when they're working with getting that, so that then we can, and it, and being employed is the goal of our programs too. So that's another aspect that would need to be retained.
Well, or not then, right? Because remember, you can always give things back.
Okay.
So, generally what I try not to do is take away stuff that doesn't need to be taken away, right? Who cares, right? If they're never going to have the ability to vote or drive or whatever, then who cares about taking away the right? That's just worthless. But really, you got to focus on the ones that are actually potentially dangerous. Like for most people, it's the right to make decisions about, it sounds innocuous to manage property or to make gifts. Well, that's manage their money, right? That's who's going to control the money, whether it's SSI or the money they earn from a job or whatever it is, that's managing money. And that's usually the biggest deal if there's money involved.
Thank you.
Of course.
Thank you. We have another. Someone asked, it's an ABLE account question. And if the disability occurred after the age of 26, are there criteria for eligibility?
Not now. With an ABLE account ABLE was passed in 2014, the enabling legislation in Florida 2016, the federal law says you have to have been disabled prior to the age of 26. Now, they are working, I can't remember if the law's already passed or if it's coming, but I think it's moving up to 49, but I don't remember when that is, but it's not yet.
Thank you. We have another question. We moved here from another state. Will our power of attorney work here in Florida until we have another one drawn up?
The answer is it depends. So I will tell you generally, if it was drafted by an attorney, if it looks like a valid power of attorney, if it was witnessed and notarized and it has kind of all the indicia and gravitas that looks like a power of attorney, you may be fine, but I would strongly encourage you to get to a new attorney and get that done.
Okay, thank you. I also wanted to share with everyone that someone had difficulty opening the PDF of the presentation that was put in the chat. Later on, I've just recently put in one that has the date and then V2 for version 2. And they've let me know that that one does open. So if you had trouble, and I also want to let you know that all of the link to the recording of this webinar, as well as a PDF of the slides from today's presentation, along with an evaluation that we would like for you to complete, will all be emailed to everyone that registered for this webinar. And so I just wanted to to share that with you because you will be receiving that, but we also like to provide it because a lot of people like to follow along as the webinar is moving along. This has been so much great information. Am I missing, if anyone else is looking in chat, if you see something that I missed, a question that anyone has presented or shared, or if anyone else has a question they would like to unmute and ask, you're welcome to do so. We have a few minutes before our time is up today.
Hi, my name is Amy, and I have a 17-year-old who has intellectual disabilities and autism. He is in a self-contained class at a public high school. So I ask all of this because it's very clear that he is not going to be able to provide for himself. Let's say if for some reason I didn't follow through on doing this and he's 18 and I need to take him to the doctor, what are my legal rights at that point?
You have no legal rights.
So that the state could take him.
No, wait. No, I didn't say anybody's going to take him away. Like, that's not how that works.
Okay.
But your ability to make legal decisions for him ends at 18. Now, I will also tell you practically, as long as you're going to the same doctor, as long as all things are the same, I've seen people come in. I've had clients come in when their kiddo was 47, right? I'm not telling you the wheels are going to fall off the bus at 18 in a day or 18 in 2 days. They may not fall off the bus at all, or it may be in that case where I had the 47-year-old person with disabilities come in with dad. What had happened is mom died. Mom was the one who had always taken him to the doctor. Mom died. Dad took her to the doctor for the very first time. And they're like, who are you? You don't have the right to make decisions. So I encourage people to get ahead of it if they can. It'll give you enormous peace of mind. But I can't, like, nothing terrible is going to happen the minute they turn 18. I can't guarantee that, but I also can't guarantee you won't have issues. So that's why I encourage people to get ahead of it. We don't file until they're 18 in 1 day. And if we do that, then a lot of the costs of the guardian advocacy go away unless you have, you hire your own counsel like me or whoever else, right? Because if you wait till they're 18 and you file for indigency, then you don't have to pay the filing fee. You don't have to pay for the court-appointed attorney because it's all based on their income and assets, not yours. Just like Social Security is, right? He may not be eligible for SSI or anything now, but at 18, he may be because that imputation of income and assets for you now, for him, doesn't exist when he turns 18. He becomes a household of one.
Got it. Thank you so much.
Of course. But please be sure, nobody's trying to take your kiddo away. That I've literally never seen that happen unless there's abuse or neglect.
Okay.
It's just, can you make decisions for them? That's really all the issue is. And for the other thing I always like to remind parents is if it's an emergency, they're absolutely going to let you make decisions, right? Power of attorney, healthcare surrogate or not, if there's an emergent situation, if there's an urgent situation, they're absolutely going to let you make decisions. It's really just a question of, gee, he needs his wisdom teeth out. Is the doctor going to let you do it or sign for him? And the answer may be no.
Got it. Thank you.
Of course.
Okay, well, we're now at 4 o'clock. Again, Catherine, thank you so much for such wonderful information. And I love tables also, Catherine, I'll tell you. And so I loved it whenever you had those tables side by side because it really gives you a better, it's a better way to understand this information because there is a lot of information. And again, this, I'll go ahead and end the recording at this time.